Hi, good morning, everyone, and welcome back to our Prestige PEO webinar series. My name is Shannon Shah. I am Operations Analyst at Prestige PEO and your host this morning. We know that the recent Roe v. Wade ruling has resulted in many questions for you all, and today we will review this ruling and how it may affect your business. As always, all webinar viewers are muted, but we encourage you to utilize the chat feature for any questions you may have, and we will address them at the end of the webinar if we have time. Of course, if your question is not answered, we will also give out contact information at the end so that we can answer your questions after the webinar. Additionally, this webinar is being recorded and will be posted on the Prestige webinar website under the resource section so that you can refer to it at any time. You can find all of our recorded webinars at prestigepeo.com/webinars. Our presenter today is Seth Peretta, a principal from Groom Law Group, who is here to give us an overview of the Supreme Court decision. Welcome, Seth.
Thank you very much. Appreciate it. Thank you all for having me today. I'm here in Washington, D.C. I work very much with PEOs, including Prestige, as well as employers and carriers and ASOs, and we've been up to our eyeballs in thinking through the implications of the Dobbs decision. So if we move to our next slide here, this is just going to outline sort of the agenda for what we're trying to talk about today. The first thing we're going to talk about is sort of background or level setting. That's for purposes of our conversation. What did the court actually do? And what does that mean in terms of states' ability to regulate access to abortion services? We'll then talk very briefly about some notable recent federal developments. One thing we are seeing with the Biden administration, which had supported Roe v. Wade and supports sort of access to abortion services, is the federal government looking to see what tools they have in their tool belt to potentially provide continued access to abortion services, including for individuals living in states that now may have abortion restrictions. We'll then talk about Dobbs and the potential employer implications, and we'll then move on to talk about travel benefits. Many employers are thinking about travel benefits, especially employers who are in states that have enacted or are likely to enact restrictions on abortion services. There are a fair number of considerations for employers, and we'll walk through those today. And the last thing we want to talk about is preemption. That's a very technical word here in Washington, D.C. that lawyers use, but it's this idea about whether or not federal law or your ERISA plan or the benefits, say, that you're accessing through the Prestige Master Plan, whether those can trump state law. And this is important because whether you're talking about the Prestige Master Group Health Plan or whether you're talking about a travel benefit, understanding when effectively you might have to defer to state law will be important. The other thing to keep in mind is that actually there is the potential for civil and criminal liability, both for the company as well as for the employees, to the extent they run afoul of state law. So understanding the preemption lens is very important. All right, so with that, we'll move to our next slide here. This is just a section on background and level setting. So obviously Roe v. Wade, this was a case dating back to 1973. And effectively what it did was it found a constitutional right to abortion. So looking at the US Constitution, it said the US Constitution affords a constitutional right to a pregnant woman to have an abortion. There was a lot of discussion around the concept of sort of viability of life. And so that was generally seen around 24 to 28 weeks. And the court said in Roe that the state may regulate and or prohibit abortion sort of after the close of that second trimester, except where it's necessary to preserve the life or health of the mother. And that was sort of the law basically for 50 years. Moving on now to the next slide. So Dobbs v. Jackson Women's Health Organization. So Mississippi had passed a law that banned abortion after 15 weeks of pregnancy, so sort of pre-viability. So this would have been a law that still allowed access to abortion for weeks 1 through 14 of a pregnancy, but after sort of week 15, the state was prohibiting abortion. That law had been enjoined, subject to the Supreme Court challenge. And what was interesting was the question presented to the court was whether sort of all pre-viability prohibitions on elective abortions are unconstitutional. The court ultimately went very far, perhaps farther than the question presented required them to do. And the court held that the US Constitution does not confer a right to abortion at all. There is no right to abortion at even 1 week of pregnancy in the eyes of this court. And thus, basically, such prohibitions are constitutional. Effectively, what it does is it allows the states to restrict abortion to the fullest extent of their law, subject to whether there is federal preemption. And we'll talk about that later today. But so as a general matter, this allows states now to regulate abortion, restrict abortion, prohibit access to abortion, criminalize abortion services. It is really given states a great deal of authority that they have not had for the last 50 plus years. Moving on now to the next slide. One thing we wanted to talk about, because I think we get a lot of questions, is, well, to what extent must an employer cover abortions at all? And there is no federal requirement right now, at least that we're aware of, that requires an employer to cover an elective abortion. And I recognize that the word elective abortion is a loaded term, given that, many would look at all abortions as potentially medically necessary care. But when I say elective, what I mean is an abortion where it's not about preserving the life of the mother because of, an ectopic pregnancy, et cetera. So while there's no federal requirement to cover elective abortions, for employers that have 15 or more employees who sponsor a group health plan or are participating in a group health plan, the Pregnancy Discrimination Act, which is an oddly named act because it's really about non-discrimination based on pregnancy, it requires that the plan cover an abortion where the life of the mother is at risk if the pregnancy were carried to term, as well as complications arising from an abortion. So as a general matter, if you're an employer with 10 employees, you have no obligation to cover any abortions, basically right now under federal law. On the other hand, if you're an employer with 17 employees, you have an obligation to cover this small class of therapeutic abortions, as well as complications arising from an abortion, as set out in the Pregnancy Discrimination Act. Now, obviously, one thing to keep in mind here is that states have the authority generally to regulate their insurance markets. And so state insurance laws can both prohibit coverage for abortions and can also require coverage for abortions. So, for example, the state insurance laws in New York might look very different from the state insurance laws in Texas. And my understanding is Prestige's policy is written out of New York, and thus it may, actually include coverage not just for those that sort of PDA defined therapeutic abortion, but also for elective abortions as a condition of a rule that applies to the carrier that Prestige uses to write its policy. All right, so when we move on now to our next slide, this just looks very high level at sort of the dynamic nature of state activity on abortion. Sort of as the court was moving towards deciding Dobbs and potential implications for Roe, we saw a lot of activity in the states in 2022. We're not going to walk through all of them, but you'll see here, there were a fair number of states that both prohibited abortion, some prohibited the delivery of methotrexate, which is the abortion pill, to residents in their state. We also saw states take protective measures to try to ensure continued access to abortion services. So really on either side of this sort of very, I want to say somewhat divisive issue, or at least political issue, states were behaving really based on what they believe to be in the best interest of their residents. Moving on now to the next slide. I also wanted to note that prior to 2020, go back one slide, I apologize. There we go. that many states have pre-2022 laws on their books. And this is going to be important when we think about potential liability for your plan, for your carrier, for you as an employer, if you're thinking of a travel benefit, is that there are pre-2022 laws that are civil as well as criminal in nature. And some of those civil laws, and Texas is really the most significant example, gives private citizens the right to sue individuals that are sort of aiding and abetting an illegal abortion. Right now, we believe that is defined by the statute as an abortion happening in Texas. So if you provided a travel benefit to someone in Texas to get an abortion in Texas, that would be aiding and abetting an illegal abortion. We don't believe that civil law would stretch to a situation where you provide a travel benefit to a Texas resident to access a legal abortion in New York. With that said, we anticipate that when the Texas legislative session begins anew in January, that they may extend this law to encompass that sort of activity, both in terms of a private right to sue, but potentially in connection with criminal laws as well. What I want to highlight on the criminal laws is that many of these criminal laws were actually enacted back in the late 1800s and the early 20th century. And they include provisions that say it is illegal for anyone to provide any means intended to, say, cause an abortion or to help someone procure an abortion. Now, these criminal laws were enacted way before Roe, at a point in time when almost every state actually prohibited abortion. And so the question is, does this reach, for example, to abortions that are performed outside of their states? So if you look there at the Oklahoma and the Texas and the Alabama laws down there, like, does that pertain to abortions performed in their states? Does that reach to abortions performed outside of their state? We don't know. The second question is, many of these laws seem focused really on sort of sort of abortion instruments and instruments designed to facilitate abortions, not so much things like a travel benefit. On the other hand, we have no guidance, so it's hard to know. So it's very sort of challenging for us to sort of do a risk analysis that we believe is certain. What I will say is, as of right now, we are unaware of any states, including the states listed on this slide, taking the position publicly that these existing laws apply to a travel benefit. That applies to residents in those states accessing a lawful abortion performed in another state. Whether they choose to interpret those laws in that sort of more aggressive fashion, whether they seek to amend and expand those laws, will be something that we'll have to watch very closely. All right, moving on now to our next slide. We're going to talk very briefly about notable federal recent developments. Most specifically, there was an EO, an executive order issued by President Biden on July 8th, and it basically calls on the federal agencies to do a host of things, including safeguard access to reproductive health care services, including abortion. And so this is one of these things we're going to talk about, which is there an avenue for the federal government to find a federal law that has preemptive effect of state laws, such that even if you're a resident, say in Oklahoma or Texas, you can continue to get access to insurance coverage, for example, for an abortion, or that providers in those states who otherwise would face, potential criminal liability could continue to perform abortions. As of right now, the federal government has not come out with any guidance that expressly provides there is some sort of coverage obligation to provide access to abortions that would trump state law. They did issue a rule very recently under a section of the Affordable Care Act called Section 1557. This happened 2 days ago. They're requesting comment on whether they can construe sex discrimination, basically under Title IX, to require coverage for pregnancy termination. So it's possible we will see something with respect to that first bullet, but so far we have not seen anything that goes so far as to say there is a federal coverage mandate such that it would trump a state's prohibition on an employer providing abortion coverage or a provider in that state providing an abortion service. One thing I do want to highlight here is on the second bullet here, which is about privacy. HIPAA, which is the law that governs health privacy, has an exception for legitimate law enforcement activities, and it allows a state law enforcement actor to send a subpoena to a group health plan and request information in connection with that legitimate law enforcement activity. We can conceive of a scenario where a state like Texas or Oklahoma is sending a subpoena to a plan or to an employer asking for who in your group health plan or which of your employees utilized a travel benefit or got coverage for an abortion. And right now, as it stands under the regs that were promulgated under HIPAA, that subpoena would appear to be a valid subpoena that would, where HIPAA would not stand as a bar to having to produce that information. So we understand that the regulators are looking at that HIPAA reg in light of the executive order, and it's possible the agencies here will try to sort of circumscribe that law enforcement subpoena exception to hopefully, to potentially protect patient health information in connection with abortion services. But it's something to keep in mind that if you add a travel benefit, just be mindful that you could end up getting a subpoena from a state. And I would expect that you should be willing and able to really defend against the production of that information, because I imagine your employees would be unhappy if you just said, "Oops, okay, here it is." So, consider that as part of a consideration around whether to offer a travel benefit, for example. All right, moving on now to the next slide. These were some other federal developments. The one thing I do want to note here is that EMTALA, this is a law that applies to basically hospitals and providers that accept Medicare. The federal government came out and said that if you accept Medicare hospital, you are required to treat abortions that constitute an emergency medical service. And so this would allow, even in states that have restricted or prohibited abortions, even therapeutic abortions, it would provide some access to individuals to receive emergency abortions as a result of EMTALA, because EMTALA would preempt that state law prohibition. The federal government's already been sued on this piece of guidance, which came out on July 11th. It's being litigated now in Texas. So it'll be interesting to see what comes of that. Moving on now to the next slide, we're going to really focus on employer implications here from the Dobbs decision. So the first thing here, obviously, is that depending on the state in which your employees reside, they may lose access to abortion coverage and related services. Now, what we're going to talk about is if you are providing abortion coverage in connection with an ERISA group health plan, which is the case if you sponsor a group health plan, whether it be through an insurance carrier or through, whether you sponsor a group health plan or you participate in the Prestige major medical plan, you may end up in a situation where your employees will no longer have access to abortion coverage if they reside in one of those states. If you are self-funding your group health plan, we believe that ERISA would generally preempt most state prohibitions that restrict the ability of a employer or a group health plan to provide access to abortion. The one exception would be criminal laws, which we'll talk about, which are not saved from preemption under ERISA. The other thing is that insurance laws, as we talked about, insurance laws are also saved from preemption. And so if you are an employer and you are sponsoring a group health plan in Texas and you are using a Texas policy, it is quite possible that your employees will not have access to abortion services under that policy. So the only other options you'd have at that point would be to self-fund your group health plan or to consider self-funding perhaps a travel benefit. It obviously may impact coverage and benefits. The other thing to note here is that it's quite possible your service providers, your carriers, your TPAs, your PBMs, they may be very concerned about administering abortion-related benefits, whether it be travel benefits or the abortion itself, or medication abortion in the form of, abortion pills, methotrexate. And so you could be in a situation where you believe you've contracted for and your employees are entitled to certain services or coverage, and uh, your business partners here are unwilling to do it because they believe their license is at issue, or alternatively, that they and their employees could face similar criminal liability. So certainly something to be aware of there. And as I mentioned at the end, some employers are considering or have already begun offering a travel benefit to assist employees who are in these states where they're lacking access to abortion services to sort of travel outside of the state to access abortion services and medications. We're going to move on now and talk a little bit about sort of the travel benefit considerations. So the first thing here, this slide sort of outlines high level some considerations for employers around travel benefits. The first thing are tax considerations. When you as an employer pay for travel that is necessary to access medical care, that is generally medical care itself. I know it sounds sort of circular, but if I pay for someone uh, buy a coach airfare ticket to fly to a center of excellence for an organ transplant, or to fly to a cancer center for cancer treatment, or to fly to New York to get an abortion, the cost of that travel that I reimburse as an employer is medical care for purposes of the federal tax code. And so the thing we're going to talk a little bit about is that because it is medical care for purposes of federal taxes, the good news is it's not going to be includable in income, subject to limits, which we'll talk about. But it also makes it medical care for purposes of things like ERISA and group health plan requirements. So when we look at the next bullet, ERISA application, because your travel benefit will likely constitute medical care, it gives rise to being a group health plan. And once it becomes a group health plan, you need to worry about a lot of rules. And so how you structure that travel benefit will be important. HSA considerations. For example, if you run your travel benefit through your major medical plan, as a general matter, because that travel benefit will constitute medical care, it cannot be made available on a pre-deductible basis for folks who have not yet met the statutory minimum deductible to be HSA eligible. Doing so would make them HSA ineligible. On the other hand, if you offer it as an accepted benefit, for example, through a HIPAA accepted employee assistance program or through a health FSA, then that generally will not constitute, that will not affect HSA eligibility, and you could offer it on a pre-deductible basis. Privacy considerations, we talked a lot about this, which is, as a general matter, you have HIPAA. HIPAA only applies to group health plans. On the other hand, because a travel benefit is going to be medical care, it is going to constitute a group health plan, and HIPAA will apply to it. That's whether it's in the major medical plan, whether it's an employee assistance program, whether it's in a health FSA. So HIPAA privacy will attach, which should be welcome news to your employees. If you were trying to do some sort of taxable arrangement outside of a group health plan where you weren't actually substantiating what the travel was for, so you could argue it wasn't medical care, it would be includable in income. At that point, it would not be a group health plan and HIPAA would not attach. The last bullet there, PEO compliance, is a technical point. We're not going to touch on it today. Let's move on now to our next slide. As I mentioned, medical care under 213 includes expenses for transportation primarily for and essential to medical care. So amounts paid for lodging while away from the home that is primarily for and essential to medical care will constitute medical care. If the medical care is provided by a physician in a licensed hospital or in a medical care facility which is related to or the equivalent of a licensed hospital, and there is no significant element of personal pleasure, recreation, or vacation in the travel. So this is really the definition of what qualifies as medical care under 213. It's going to be transportation and lodging. To be clear, meals are not eligible for reimbursement on a tax-free basis, but transportation that is primarily for an essential to, as well as lodging, can constitute medical care and can be excluded from the employee's income. Moving on now to the next slide. There are three categories really to focus on when we're talking about the tax issues. There's the transportation, so it's yes, but with certain limits. So, for example, taxis, buses, trains, coach fare in airplanes, rental cars. If someone wants to get reimbursement for gas, that's permitted. You can either reimburse them for the actual cost of their gas and tolls, or there is a federal mileage rate. Meals, generally no. And lodging, but only up to $50 a day or $100 a day if a companion travels and the companion's travel is necessary to that medical care. For example, you have a minor age individual trying to access an abortion, where the companion of a non-minor adult or custodian is necessary to that medical care. Now, most folks will look at that $50 a day and say, well, that's crazy. Where can someone stay for $50 a day? Unfortunately, that is in the statute that was added to the statute, I think, back in 1986, and it is not indexed. And so it is a very small amount. Employers can certainly reimburse more than lodging. They could also reimburse meals. They could reimburse other sorts of travel expenses beyond that, which is allowed for under the under the Internal Revenue Code. If they do, that money, that reimbursement above those IRS limits would be taxable income. It would have to get taxed as wages and reported and withheld upon, or otherwise imputed as income. And I think one question we're hearing from employers is we've contracted with the TPA to administer the travel benefit, but they don't want to go beyond the IRS limits because of the challenges of dealing with that sort of issue. So something to talk about if you're thinking about a travel benefit. All right, moving on. Oh, I see a question. Can employers gross up to cover the taxes? Absolutely. So you can certainly do that. Can you provide just a flat dollar amount towards the benefit? Yes, you could say if you're someone who is going to have an abortion, we're going to give you $2,000 period. Let's say you're covering the abortion, but then you just want to give them $2,000, which in theory is for travel or other sorts of things, but you're not going to substantiate it. You could certainly do that as well. Those amounts would be includable in income because you're not substantiating what that $2,000 or how that $2,000 was used, and it would be includable in income. And again, you could gross it up. As I mentioned on companion travel, it can be medical care if it's necessary to enable the person to receive the medical care. Here are some examples where necessary, right? If there's parental consent that needs to be there for a minor, if there are waiting periods, and the individual, has to be there, say overnight, or there's sedation involved, situations like that, typically companion travel would constitute medical care, and the amounts reimbursed up to IRS limits for that companion would also need to be excluded from income and would constitute medical care for purposes of ERISA and group health plan rules. All right, moving on now to the next slide. So here's where a question, okay, so I say you're an employer, you're like, I really want to do a travel benefit. It's really important to me. I'm either going to just do it subject to the IRS limits, or I'm going to do IRS limits plus. But now I got to figure out where I put it. Do I do it inside my major medical plan, or do I do it outside the major medical plan? Well, obviously, if you're participating in the Prestige major medical plan, you should talk to Prestige about sort of what they're able to offer, because it may necessitate you having to just do something outside the major medical plan. If you're sponsoring a small group policy, talk to your carrier, see if they have options for doing a travel benefit inside the major medical plan. If not, you may need to do something, as a sidecar or outside that major medical plan. If you do it inside the major medical plan, it's generally going to be limited to employees and dependents of those employees who are enrolled in the plan. So if you have folks who are ineligible for the plan or who opted out, typically they won't be able to access the travel benefit if you do it inside the major medical plan. You may need to amend the plan or add a rider or endorsement if it's an insured policy. And, you know, well, if we go to the outside the plan now, how can we do it outside the plan? I've got an insured policy, it's small group, my carrier is telling me they won't do it, or it's whatever. So what can I do if I do it outside the plan? Well, the benefit of doing it outside the plan is it can be available to all employees and their spouses and dependents, so including folks who were ineligible to participate in the major medical plan or people who opted out. But as I mentioned, it constitutes medical care, likely. And so you're going to end up having a mini group health plan. And then because it's a mini group health plan, you can't just offer it on a standalone basis because it wouldn't meet all the federal law requirements that apply to a group health plan. So you then have to look around and say, okay, where can I put it or how can I make it work? And there's a couple options here. One is you could do it as an EAP, as an employee assistance program. Now, if you do it as part of the EAP, you're going to have to meet sort of a series of rules that apply to employee assistance programs that were issued by the federal agencies during the Obama administration. But the upside of using the EAP is maybe that you already have an EAP and an EAP provider, and the EAP provider is willing to actually administer the travel benefit. And so you can just stick it in the EAP and move forward. And it can be available to all folks enrolled in the EAP, and you're great. The other option is potentially utilize your health FSA. Now, the issue with the health FSA is obviously you could say to employees, if you anticipate having an abortion, you should salary reduce more so you can cover your travel, right? But typically abortion, I don't think is something that is planned. So that may not necessarily work. Employers can, however, put in a non-elective employer contribution into an FSA that is equal to the greater of $500 or the amount that the employee pre-taxes into the FSA. So if you have an employee who pre-taxes less than $500, you can put in $500 into the FSA, which they could then use for abortion travel expenses. Alternatively, if you had someone who contributed $1,000 into their FSA, you could have that travel benefit you could have the employer non-elective contribution be as much as $1,000 for that employee. Now, one thing to keep in mind is even if you're doing this, again, outside of the major medical plan, because it constitutes medical care, you likely will need to exclude from income if you go over those IRS limits. That would be imputed as income, and then you decide whether you gross it up. All right, moving on now to the next slide. Preemption. All right, I know you guys are like, oh, who cares about preemption? But I do want to make sure you understand it because it has the potential to impact whether you might face civil and criminal liability as an enterprise, as well as employees and officers at your company. So you'll see here ERISA, which is a federal law that applies to employer-sponsored group health plans. It says ERISA shall supersede any and all state laws. That's awesome, right? So I don't need to worry about state laws. Insofar as they may now or hereafter relate to any employee benefit plan. So I look at this and I feel pretty good. I'm like, great, I've got an ERISA plan, whether it's an EAP, whether it's the FSA, whether it's a HIPAA accepted HRA, that's integrated with my major medical plan, whether it's in my major, I'm going to cloak myself with the risk of preemption. I'm going to be good to go. Now, one thing to keep in mind is if you want to do a taxable benefit where you're not substantiating and you just want to give them cash and you're not going to ask for receipts and they can use it for anything they want related to an abortion, and say you're covering the abortion over here in the medical plan, that does not constitute a group health plan. So the good news is you don't need to worry about group health plan stuff. The bad news is ERISA doesn't apply to that. And so you can't avail yourself of ERISA preemption if you just give them cash, because that's not an ERISA benefit. It's not an ERISA arrangement. And one of the things that might be very important in protecting folks from liability is ERISA preemption. Moving on now to the next slide. I'm feeling pretty good. I'm feeling good. I've got my plan. I've got ERISA preemption. I'm like, you state, you come after me. I'm going to get you. I'm going to win. The problem is ERISA doesn't preempt a few laws. One is it doesn't preempt state insurance laws. So again, if you have a carrier and your carrier is prohibited from covering abortion or from adding a travel benefit, you can't say to your carrier, I want it, you better do it. Because that carrier may not have the ability to add that benefit. On the other hand, if you self-fund your travel benefit, so maybe you have a small group policy, and then next to it, you self-fund a travel benefit. Well, at that point, your benefit for the travel is self-funded, and the state law would not apply to that aspect of your plan because your plan is now self-insured. And as we said, ERISA preempts state laws except for insurance. So you're like, great, I'm going to have my fully insured policy for major med. I'm going to provide a self-funded travel benefit that maybe my carrier will administer for me, or I'll find someone who will, or maybe I'll do it in-house. And I recognize it's a group health plan. I'm going to have to understand HIPAA, but I'm going to do it right. And I'm going to be great. And so to the extent you have civil laws that are prohibiting travel benefits or assisting people accessing abortions, you're going to be fine. The other problem here is that ERISA does not preempt criminal laws of general applicability. Now, right now, we are unaware of any criminal laws of general applicability that criminalize the offering of a travel benefit, right? So going back to like slide 5, and we talked about those civil laws and those criminal laws that have been on the books for a long time. It's possible those laws could be read to criminalize a travel benefit. We're not aware of any of those states taking that position at this point. We suspect that if states criminalize travel benefits, it's going to be done legislatively in the 2023 legislative sessions of these states. But it's certainly conceivable that someone will pass a law that is of general applicability, meaning it doesn't target ERISA plans, it doesn't target employers. Maybe it says it is a criminal violation to provide financial assistance to help a resident of our state access an abortion performed anywhere. Right now, that criminal law would be of general applicability, and ERISA would not preempt it. So even if you did an FSA, even if you did major medical plan travel benefit, even if you did an employee assistance program, right? ERISA would not preempt that law. And so at that point, criminal liability could attach to your enterprise as well as to your officers, your directors, and your employees. Right now, we're not aware of any criminal laws that reach that far that are of general applicability. So it's a hypothetical at this point, at least we believe so. But if you are going to add a travel benefit, it is going to be really important that you monitor state law, because we are anticipating that when the legislative sessions begin anew, now Indiana just called a special legislative session, but we're anticipating that some states may criminalize travel benefits or financial assistance or things like that. And if they're of general applicability, it could result in potential liability to you. I say this not to scare you, but more like if you're going to do this, it's not a do it and walk away and it's on autopilot and I'm done. In order to manage risk for the enterprise as well as for your employees, you will need to be monitoring state law developments if you do a travel benefit. And now if you're in one state and you're in a New York or you're in a that sort of state, chances are, your risk is really small. If you're an employer located in a state with these sort of restrictions and prohibitions, or you have employees, maybe you're a New York employer, but you have a lot of employees in Texas or Oklahoma or Idaho or Indiana, Oklahoma, you'll want to be monitoring those state law developments to the extent you're doing a travel benefit. All right, moving on now to the next slide. So this is just a summary of what ERISA would preempt and would not preempt. We're not going to walk through it. The last bullet I want to highlight here is that even if ERISA doesn't preempt, there are actually a host of other defenses about why a state law prohibition shouldn't be given effect. So let's say I pass a law that says, I'm Oklahoma, and I pass a law that says it is a criminal violation, is a violation of the Oklahoma Penal Code to provide financial assistance to a resident of Oklahoma to access an abortion performed in Oklahoma or within the 50 states of the United States. Like, ERISA would not preempt that because that is a criminal law of general applicability. On the other hand, we think there are probably a lot of other reasons why that law is invalid. One thing is generally there is a right to interstate travel. And so restricting the access to travel in this way might violate that right. The other thing too is there's rules against extraterritoriality. The idea that one state can reach into another state and regulate conduct happening in that state. And gosh, well, if the abortion is happening in New York to that Oklahoma resident, what right does Oklahoma have to regulate that conduct occurring in New York? Now, many of these sort of defenses, which are not preemption based, we anticipate they will all get litigated and it will take years. And so the question for you is, while this is happening, and while we're waiting for the law to become clear, are you comfortable with that level of risk? So something just to keep in mind. All right, moving on now to our next slide. Questions, comments, discussion. So hopefully with 18 minutes left to spare, we have time for some questions. And I'm not sure, Prestige folks, how you want to manage this. If you just want me to run through the chat or whether you guys want to team up for me, I defer to you all. Well, I can pull up the chat while we wait. Let's see here. In theory, I can pull up the chat. I have to find the chat. Here we go. All right. So someone says, for the FSA, is it safe to say that the employer can match up to the maximum contribution of $2,850? The answer is yes. This is because the IRS rules allow an employer to make a non-elective contribution as a 100% match on the employee contribution. So you can't do more than 100% as a match, but you can match up to 100% of what the employee contributes, which is the maximum contribution you said there of $2,850. I haven't checked the limit there on $2,850, but assuming that is the current limit for 2022, yeah, that is correct. Can you just provide a set amount towards a travel benefit? You absolutely could. You could say, I'm going to provide $2,000 towards a travel benefit. But I'm not going to substantiate what those amounts were used for. And so somebody could have used them entirely for Twizzlers at the hotel while they were waiting for, during that waiting period that's required by state law. That would be includable in income. It would not be medical care, and notably ERISA would not preempt. So, but yes, that would certainly be possible. Can employers gross up to cover the taxes? The answer is yes. There's nothing that prohibits that. Wouldn't the right to sue for assisting in abortion be in conflict with HIPAA laws? Unfortunately, the answer is no. HIPAA is just a privacy provision about when the group health plan can disclose protected health information. The right to sue under Texas law, which is it's SB 8, it was a legislative vehicle that was actually enacted prior to Dobbs. It was actually intended to be an end run around Roe because it didn't require state enforcement. It would be enforced by private citizens through litigation. And the Texas Supreme Court, sorry, the U.S. Supreme Court said that did not conflict with Roe because the state wasn't restricting access to abortion. It was private litigants. I think folks were surprised by the decision the court came out with. Interestingly, California is now using the same approach Texas used on abortion on gun control. So California is like, wow, if this works, we can let private citizens in California sue other people for having assault rifles. So it's interesting to see sort of how the blue states are now using that decision. As I also mentioned, HIPAA has an exception from disclosure for legitimate state law enforcement activities. So unfortunately, HIPAA itself would not stand as a bar or prohibition to a law enforcement subpoena. Let's see here. So this is very helpful. Do we know when and if United Healthcare will announce if they will add a travel benefit under the plan? I will say that United Healthcare, I believe, is assisting employers in providing travel benefits if they want to add a travel benefit in connection with their group health plan. I think one of the issues that may exist here is that for fully insured master plans, because of state insurance laws that are saved from preemption, I'm not entirely sure whether United Healthcare is offering a travel benefit in connection with large group insurance arrangements. So that may be something to talk to United Healthcare about. Um, I don't see any other questions. So unless the Prestige folks have any questions in the queue that I have missed, I really appreciate everyone's time.
I do
Uh,
see that someone asked if this is downloadable. I'm going to mention that in the closing statement, if these slides are downloadable. Thank you so much, Seth, for this extremely valuable presentation, and thank you to everyone for joining us. You can view this webinar information on our website at prestigepeo.com/webinars, and you will be able to download this there. We will also post Seth's contact information on the webinar landing page if you have further questions, and you can always reach out to your HR business partner for additional guidance. As always, we appreciate your feedback, so please feel free to share your opinions on today's presentation so that we can continue to develop webinars with the information that you and your employees need the most. Be sure to check your inbox for our monthly Insights newsletter, which will give you the latest HR news information you need. You can also follow us on Facebook, LinkedIn, and Twitter for current happenings at Prestige and the latest information. Listen to our latest podcast, HR in 15, for information packed episodes in a bite sized package. And finally, remember to download our Prestige Go mobile app for access to your benefits information and support to your HR team members on the go. Thank you, and we'll see you all next time. If there are any other questions in the chat, we will reach out to you directly.